Hello friends, I am Krishna Kumar, Faculty of Law at School of Law, Dr. Hari Singh Gaur Vishwavidyalaya, Sagar, Madhya Pradesh. Today's topic of our discussion is learning all about Explosive Substances Act 1908. But before I move ahead to the introduction of this discussion, let me introduce you about what we are going to learn today. Today's lecture is divided into following modules. Module 1, Introduction. Module 2, Premises of the Act. Module 3, Scope and Application. Module 4, Definition. Module 5, Punishments under the Act. Module 6, Restriction on trial of offence. The Explosive Substances Act 1908 is an act to amend the law relating to the explosive substances. This act is enacted to fill the gap resulting out of the inadequacy of existing law to deal with the crimes committed by means of explosive substances. This act was enacted in 1908, that is prior to the enforcement of the Constitution. But by virtue of Article 372 of the Constitution of India, the Explosive Substances Act is continued in force in the territory of India. Now, we will discuss the background leading to the enactment of the Act. The Indian Explosives Act 1884 was framed to prevent accident rather than to prevent crime. Its provisions are clearly inadequate to meet the present, as no sentence of imprisonment can be imposed under the Act, and the maximum penalty is only a fine of 3000 rupees. The Indian Arms Act 1878, though it applies to the possession of explosives as well as arms, is also inadequate in respect of both the penalties. It allows an scope of its provisions for dealing promptly with the provisions to manufacture bombs and other explosives. The Indian Penal Code 1860 provides for the punishment of persons to cause hurt or mischief by means of explosive substances, and it also deals with the attempts to cause hurt or mischief, but only when any act toward the commission of the offence is actually done, but it does not provide any penalty for making or possessing explosive substance with unlawful intent, and it does not in other cases always provide such severe penalties as are requisite. The Governor General in Council therefore considered it necessary to supplement the existing law by an act on the lines of English Explosive Substances Act 1883, which was enacted for the express purpose of dealing with the anarchist crimes. The bill, which has been drafted to give effect to this decision, provides for the punishment of any person who causes an explosion likely to endanger life or property, or who attempts to cause such an explosion, or makes or has in his possession any explosive substance with intent to endanger life or property. It further makes the manufacture or possession of explosive substances for any other than a lawful object and a substantive offence, and throws on the person who makes or is in possession of any explosive substance the onus of proving that the making possession was unlawful. It also provides adequately for the punishment both of principals and accessories. Section 1, short title, Extent and Application. 1. This act may be called the Explosive Substances Act 1908. 2. It extends to the whole of India and applies also to the citizens of India within and outside India. Section 1 of the Act specifies that this Act may be called the Explosive Substances Act 1908, and it extends to the whole of India and applies to the citizens of India within India and outside India. In this part, we will discuss about the definitions of some words as are defined in the Act. Section 2, Definition of Explosive Substance. In this Act, the expression explosive substance shall be deemed to include any materials for making any explosive substance. Also, any apparatus, machine, implement or material used or intended to be used or adapted for causing or aiding in causing any explosion in or with any explosive substance. Also, any part of any such apparatus, machine or implement. The term explosive under section 2 is defined explosive substance within the meaning of this section would include also any explosives ready for explosion. If it includes a part, it would surely include the whole finished product ready for the explosion within the mischief of this section. The expression explosive substance has a broader and more comprehensive meaning than the term explosive, which is defined in the Explosives Act 1884. Under section 4D, as explosive means gunpowder, nitroglycerin, nitroglycol, gun cotton, dinitrotoluene, trinitrotoluene, picric acid, dinitrophenol, trinitroresurcinol, stephanic acid, cyclotrimethylene, trinitramine, pentaethyrotol tetranitrate, tetraethyl nitroguanidine, lead azide, lead stiphanate, fulminate of mercury or any other metal dinitrophenol. Colored fires or any other substance, whether a single chemical compound or a mixture of substances, whether solid or liquid or gaseous, used or manufactured with a view to produce a practical effect by explosion or pyrotechnic effect, and includes fog signals, fireworks, fuses, rockets, percussion caps, detonators, cartridges, ammunition of all descriptions, and every adaptation or preparation of an explosive as defined in this clause. But as the Explosives Act 1884 is designed to control the manufacture, possession, use, sale, transportation and importation of explosive so as to prevent accidents, on the other hand, the Explosive Substances Act 1908 seeks to control crimes arising out of the illegal use of explosives. Therefore, relying on the meaning of explosive in the Oxford Concise Dictionary to the effect tending to expand suddenly with loud noise, tending to cause explosion, the Supreme Court held that the following items in the quantity noted against each found in the conscious possession of the accused without a valid license were covered by the definition of explosive substance and thereby upheld the conviction. First, 200 grams of highly explosive gunpowder. Second, 40 kilogram and 150 grams of blasting powder. Third, 3 kilogram and 350 grams of mixture of potassium chlorate and sulfur. Fourth, 54 detonators. Fifth, 251 caps like contrivances containing prohibited mixture of red arsenic sulfide and chlorate used to act as improvised percussion caps. Sixth, 104 kilogram and 500 gram of potassium chlorate. Seventh, 37.5 kilogram of special gelatins. Eighth, 300 kilogram of sulfur. Ninth, 2496 campion crackers of prohibited size and containing prohibited mixture. 10, 510 grams of potassium cyanide. 11, about 450 kilogram of sulfur. 12, 217 caps like contrivances of the description as in the case with the item 5 above. 13, 2500 detonators. 14, 27 live cartridges and 12 bores and 15 mixture of sulfur and potassium chlorate half kilogram. The definition of explosive substance is inclusive and by no means exhaustive. Any contrivance by itself or with the help of another which would go to make an explosive substance is covered by the definition. Thus, hand grenades not fitted with igniter set are explosive substances, despite the fact that in order to explode them, ignite set has to be fitted to such types. Gunpowder is explosive substance within the meaning of this section, but phosphorus in natural form kept in a bottle containing water is not an explosive substance. The explosive substance need to be such as to enable a person by means thereof alone without the aid of other substance to cause damage to life or injury to property. Any part of any apparatus, machine or implement intended to be used or adopted for causing and aiding in causing an explosion is included in the term explosive substance. In this module, the punishments for the various acts committed are prescribed, which are prohibited and declared as offences under the Act. Section 3. Punishment for causing explosion likely to endanger life or property. Any person who unlawfully and maliciously causes by an explosive substance an explosion of a nature likely to endanger life or to cause serious injury to property shall, whether any injury to person or property has been actually caused or not, be punished with transportation for life or any shorter term to which fine may be added, or with imprisonment for a term which may extend to 10 years, to which fine may be added. This section 3 of the Act aims on causing an explosion unlawfully and maliciously, which must be proved in the ordinary way. Malice in the legal acceptance of the word is not confined to personal spite against any individual, but consists in a conscious violation of the law to the prejudice of another. It is a wrongful act done intentionally without just cause or excuse. It is in that legal sense that the word maliciously is used in section 3 of the Act. The expression unlawfully signifies not for a lawful object, and the term maliciously means and implies an intention to do an act which is wrongful to the detriment of another person. A man is said to act maliciously when he intended to do the very unlawful act which he is charged, or if the act is necessary consequence of some other criminal act in which he was engaged, or where the act or ought to have foreseen the consequences and yet persisted in the unlawful act in which he was engaged. Malice in criminal law means willfully or intentionally and without lawful excuse. Regarding burden of proof, where the prosecution has proved the possession of hand grenades with the accused, it is for the accused to plead justness of the case of possession or a valid excuse. It is only in that event that the prosecution has further to prove that the cause or excuse so pleaded or suggested was in fact without justification. In case of explosion causing minor injuries, so far as the charge under section 3 of the Act is concerned, it has to be established that the accused concerned had caused an explosion of nature likely to endanger life or cause serious injury to property. Where the bombs thrown by the accused at the police party were proved to have caused only minor injuries to some of the police constables by splinters thrown out of the exploded bombs, and where the evidence of the expert showed that although a chemical examination of remnants of country made bomb indicated existence of potash chlorate and arsenic sulfide therein, it was on the quantity and proportion of the said ingredients about which there was no evidence that the mischief making power of a bomb depended. It was held that the bombs were not of such a nature as to cause explosion likely to endanger life, and hence the requirement of section 3 were not satisfied. Section 4. Punishment for attempt to cause explosion or for making or keeping explosive with intent to endanger life or property. Any person who unlawfully and maliciously a. does any act with intent to cause by an explosive substance or conspires to cause by an explosive substance an explosion in India of a nature likely to endanger life or to cause serious injury to the property, or b. makes or has in his possession or under his control any explosive substance with intent by means thereof to endanger life or cause serious injury to property in India, or to enable any other person by means thereof to endanger life or cause serious injury to property in India, shall, whether any explosion does or does not take place and whether any injury to person or property has been actually caused or not, be punishable with transportation for a term which may extend to 20 years, to which fine may be added, or with imprisonment for a term which may extend to 7 years, to which fine may be added. The essential ingredients of an offence under section 4b is that the accused must be found to have in his possession or under his control some explosive substance with the intention of endangering life. A man may be in close proximity to an objectionable substance such as bomb or other explosive article, and the same may even burst where he is in that position. It can hardly be said that from this fact alone it is proved that he had possession or control over that article within the meaning of the said section. Thus, word unlawfully and maliciously in the opening part of the section clearly indicate that the man charged must have knowledge of the existence of the article near him, and that he must also have an intention to cause injury to life or property by means thereof. Section 5. Punishment for making or possessing explosives under suspicious circumstances. Any person who makes or knowingly has in his possession or under his control any explosive substance under such circumstances as to give rise to a reasonable suspicion that he is not making it or does not have it in his possession or under his control for a lawful object shall, unless he can show that he made it or had it in his possession or under his control for a lawful object, be punishable with transportation for a term which may extend to 14 years, to which fine may be added, or with imprisonment for a term which may extend to 5 years, to which fine may be added. For the purpose of section 5, the accused must not only knowingly have in his possession the substance, but must also know that it is an explosive substance. The knowledge whether a particular substance is an explosive substance depend on different circumstances and varies from person to person. A person of experience may know that the substance is explosive. In the case of Dula Singh versus Emperor, year 1928, Lahore 408, Sir Shadi Lal, delivering the judgment of the bench, pointed out that not only the term possession implies knowledge, but expression maliciously connotes intention, but neither knowledge nor intention as to the use to be made of an object can be imputed to a person who is not conscious of its existence. The onus of proof regarding possession. The prosecution must prove conscious possession or actual control of the incriminating objects, remembering at the same time that possession need not always be manual possession, that is, possession by physically touching the incriminating objects. Control is a wider concept than possession, but there again the control must be actual, not only merely constructive. The prosecution must prove mens rea. It is impossible for more than one person to be in conscious possession or actual control of an incriminating object, but whether they are in such possession or not must be inferred from the facts and circumstances proved. When the aforesaid two conditions are fulfilled, then onus changes, and it would be for the person in such possession or control to explain his possession or control. Under section 5 of the Act, it is enough if the prosecution is able to establish that a reasonable suspicion exists against an accused person, that he has made or knowingly has in his possession or under his control any explosive substance, and that he is not in possession of such substance for any lawful object. The burden is upon the accused person once it is shown that what he made or was in his possession is an explosive substance, to establish that he made it or had in his possession for a purpose which is lawful. Therefore, to attract the section, it must be first shown by the prosecution that what was recovered from such accused persons was explosive substance. If the witness to the search and seizure describe the object recovered by the police at the instance of accused persons as bombs, that does not bring them within the meaning of explosive substance. It is for the competent analyst to say or opine whether the substances recovered by the police are explosive substance or not. It is enough if the prosecution is able to establish that the objects examined by the analyst were found to contain explosive substance, and it has further to establish that what was examined by him were the identical objects that were seized from the house of accused. If more than one person are in conscious possession or actual control of an incriminating object, here is Chief Justice in Emperor versus Santa Singh stated as follows: I do not suggest that the recovery of an article in a house occupied by a number of persons is proof of joint possession, but that the fact coupled with other evidence might establish such joint possession. All I desire to point out is that the exclusive possession or control of any particular person is not required under these sections. The possession or control might well be possession or control of two or more persons. Therefore, it would not be legally permissible to call upon all the occupants of the place to account for the presence of the incriminating article in their premises, and in the absence of any satisfactory explanations on their part, to hold all of them to be in possession or control of the same. In case where incriminating articles are recovered from a place in the occupation or possession of more persons than one, and it is not possible to fix the liability on any particular individual, a court is not bound to hold that the said article was in possession or control of the head of the family. It is also clear that Section 106 Evidence Act has no application until the prosecution has proved conscious possession or actual control with guilty knowledge. So, we can say that in order to bring the offence under Section 5 of the Explosive Substances Act, the prosecution has to prove: number 1, that the substance in question is explosive substance; second, that the accused makes or knowingly has in his possession or under his control any explosive substance; and third, that he does so under such circumstances as to give rise to a reasonable suspicion that he is not doing so for a lawful object. The burden of proof of these ingredients is on the prosecution. The moment the prosecution has discharged that burden, it shifts to the accused to show that he was making or possessing the explosive substance for lawful object. If he takes that plea where it was alleged on the behalf of the accused that the charge under Section 4B of the Act was defective, inasmuch as it omitted to state first that the accused were in possession of explosive substance or had them in their control unlawfully and maliciously, and secondly, that it was the intent of the accused to endanger life, held those defects in the charge did not vitiate the trial and conviction. Section 6. Punishment of abettors. Any person who by the supply of or solicitation for money, the providing of premises, the supply of materials, or in any manner whatsoever procures, counsels, aids, abets, or is accessory to the commission of any offence under this Act shall be punished with the punishment provided for the offence. Section 6 of the Act provides that any person who inter alia by supply of materials procures, counsels, aids, abets, or is accessory to the commission of any offence shall be punished with the punishment provided for the offence. The commission of the offence is necessary ingredient of the offence under the Section 6 of the Act, and ordinarily it is the primary intention of the accused that must be taken into consideration in determining his guilt. In this part, we will discuss about the restrictions imposed by the Act regarding the trial of the offences under the Act. Section 7. Restriction on trial of offence. No court shall proceed to the trial of any person for an offence against this Act except with the consent of the central government. Under Article 258(1) of the Constitution, the functions exercisable by the President in relation to any matter to which executive power of the Union extends may be entrusted by him to the state government with the latter's consent. Section 7 embodies one of such functions which may be performed by the President in the exercise of his executive power, namely the function of according consent in respect of an offence against the Act. It follows therefore that if the President makes a notification in terms of Article 258(1), it would have the effect of delegating the functions of the President to state government. By notification number 33/2/57 Police 4 issued by the Ministry of Home Affairs, the President has entrusted to all state government with their consent the function of the central government under section 7 of the Act. Consequently, the state government have jurisdiction to give consent in respect of an offence against the Act. The state government, by virtue of the powers delegated under section 7, is not entitled to exercise the powers conferred under section 432(7) of CRPC to grant remission or suspension of sentence, where the central government only wants to entrust its executive function under an act to any state government. An order under Article 258(1) is quite sufficient, and the Act itself need not contain any provision for such delegation or entrustment. Where the Governor gives consent to the prosecution under section 7 of the Act, the question whether it was given after the consultation with the ministers or not cannot be canvassed in the courts of law. By notification number 33/2/57 Police 4, the Government of India has not given a general consent to all prosecutions that may be instituted by subordinate authorities, but to entrust the power of giving consent to the state government. In each individual case, therefore, the state government will consider the facts of the case and apply its mind to the question whether or not such consent should be given. Conclusion. So friends, in this lecture, we have tried to understand an overview of the law relating to the explosive substances. Hope this lecture has given you wide knowledge on the scope and extent of the Explosive Substances Act 1908. The main object of the Act covered under the topic is to prevent crimes rather than to prevent accidents. It also discusses the definition of the explosive substance as is given in the Act. We have covered the punishments prescribed for the various offences covered by the Act. These punishments are for the causing of explosion likely to endanger life, person or property, for causing explosion with the intent to commit offence, for the attempt to cause explosive, or making or keeping explosive with intent to endanger life, person or property, for exploding, making or possession of explosives under suspicious circumstances, and also the punishment for the abettors of the offences committed under the Act. With all these informations, here we come to an end of today's lecture. Do keep in mind that what we have discussed today, it's time for you all to do some self-study. This is Krishna Kumar signing off. If you want to learn more and enhance your knowledge, you may log on to our website for multiple choice questions, quizzes, LORs, www.cec.nic.in. Till then, keep using the information technology, be alert and be safe on internet. Wish you a cyber safe environment. Till then, goodbye.